The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones, a family law attorney with O'Flaherty Law, and today we're going to do a how-to video for filling out a joint petition for divorce without minor children. This is Form FA-4111V. It's available on the Wisconsin Court website. It does come with some basic instructions on the left-hand side of the page, but we're going to walk through and clear up any confusion so that you can fill out your joint petition correctly the first time and move the process along. This video is for educational purposes only, and it is not legal advice. If you have questions or concerns regarding your divorce, you should consult with an attorney. So, looking at the form here on the screen, you can see in the top left-hand side, you identify each petitioner. It doesn't matter who picks petitioner A or who is petitioner B. Just pick one and stick with it throughout the form. Then you move on to what county will you be filing in. Residency requirements for the state of Wisconsin are that you have lived in the state for 6 months prior to filing, and in the county where you file, you need to have lived there for 30 days before you meet all the residency requirements. So when you're filling in your county that you're filing in, make sure it's the county that you've lived in for 30 days. Over here in the top right-hand corner of the page, it's intentionally left blank and kind of marked off there. That is for the clerk of courts. When the two of you go in and file your petition, they will file stamp it the date they received it. That will start the clock running. And also put in any further information to identify the case to keep everything organized. So just don't put anything up here on the top right-hand corner. Moving on to identifying the matter. So this is in regard of the marriage of joint petitioner A, joint petitioner B. Remember, you're picking a letter and you're sticking with it throughout the form. Obviously, name, address, city, state, and zip for both. Over here, you'll see the title of the form, the joint petition without minor children. And underneath it, you'll see options to select either divorce or legal separation, because the process to start both is they use the same forms in the Wisconsin system. But as you can see, they're differentiated and they have different case codes. That is because legal separation and divorce are two different things. If you are legally separated, in the eyes of the law, you are not divorced. So you need to be very careful when you're considering legal separation, because it is not the same as divorce, and we can talk about that a little bit more later on in the video. You will not put anything in the case number entry here. That is for the clerk of courts. They will assign you a case number. However, if you were to come back and file an amended petition, you would use the case number that is assigned to you when you file the first petition. Moving on to identifying information. Once again, petitioner A, date of birth, and then we have the residency questions. We talked about residency earlier in the video. The residency requirements for Wisconsin are that you have lived in the state for 6 months or more, and you've lived in the county that you are filing in for 30 days or more. Next, they want to know if joint petitioner A is in active duty in the armed forces. The court will sometimes waive certain residency requirements or even stay a divorce proceeding if one of the parties is in active duty and maybe even deployed into an active war zone. If you're an active duty member of the armed forces, there are some allowances made simply because you can't really control where you are or what you're doing. So they always want to know if the people involved in the divorce case are in the armed forces. Then they're going to ask question number 5, is joint petitioner A currently pregnant? The reason why is that a pregnancy during a marriage, paternity is typically presumed, but if the pregnancy is not with the spouse, the court needs to know about it so it can take the appropriate steps later on in the action when it comes to things like making decisions on child support, custody, or visitation, or even ordering paternity testing. So that's petitioner A, and then we do it again for petitioner B, date of birth, the 2 questions regarding residency, whether or not petitioner B is an active duty member of the armed forces, and whether or not joint petitioner B is currently pregnant. So once things like residency, status are answered, the court would like to know when and where you were married so that it can have an idea of how long the marriage has been. This could come into play if somebody's asking for spousal support. The state of Wisconsin might want to know if it would be considered a short-term marriage, long-term marriage. How long was the marriage? Moving on to question 3. We discussed this a little earlier in the video, but the court wants to know if you're asking for a divorce or if you're asking for a legal separation. Now, Wisconsin is a no-fault divorce state, and that means that there really is only one way to handle why you're getting divorced. You just say that the marriage is irretrievably broken. It doesn't matter if the other person was a bad spouse. It doesn't matter if there was infidelity. The court isn't going to take that into account when granting a legal divorce. The court just needs to know that the marriage is irretrievably broken. And then, if you're not asking for divorce and you're asking for a legal separation, the court wants to know why. Now, there are many different reasons why people just get a legal separation instead. A few of them would be that for financial reasons, it's better to stay married. As an example, the marriage isn't working out, but the 2 of you are still great friends, and one of you wants to be able to keep your spouse on your health insurance. Or possibly for religious purposes, you simply just don't believe in divorce, but you just don't want to live with that person anymore. So this is where you would ask for a legal separation. There is a caveat, though, a warning about legal separation. Like I said earlier in this how-to video, a legal separation is not a divorce. In the eyes of the law, you will still be married. This can come into play when considering marital assets and debts. Anything acquired during the marriage is considered marital unless it was given by gift, will, or given to you in someone's estate. So most of your assets and debts that you acquire during the marriage are considered marital. And an example of how that could backfire is if you only get a legal separation and you kind of go on your way, the 2 of you go start leading separate lives for the most part, but then your spouse racks up a bunch of debt and files for bankruptcy. You would still be involved in that process. Or if your spouse just owes a bunch of money to creditors, the creditors could come after you because it would be a debt acquired during the marriage. So that is how a legal separation could very negatively impact you in the future, at least financially. So it's something to talk very, very seriously about with your spouse and decide if that's really a viable option, especially considering that this is a joint petition without children and you don't have to consider the care of children moving forward. After you've clarified to the court whether you're asking for a divorce or a legal separation, the court wants to know if you have previously filed for divorce or legal separation from each other in Wisconsin or in any other state. If you have, you need to give the information on that. If you've previously filed for and been granted a legal separation and now want to divorce, you need to file a different form asking that the separation be converted into a divorce proceeding. If you previously filed in Wisconsin but cannot remember the information, you can look it up on the Wisconsin Circuit Court Access Program. Just do a name search for yourself and your spouse, and that would provide you with the case number, and you could be certain that the case had been dismissed or not dismissed. If it's in any other state, hopefully you've kept good records. I'm a Wisconsin attorney. I'm not quite sure what search options are available in other jurisdictions. Then they want to know whether or not this is joint petitioner A's first marriage. They give you two sections here. If you've been married more than twice before, you can put it on a separate sheet of paper and attach it to the form. Going through this form, do not alter anything in the form. Don't go in and take out the instructions on the left. Don't add lines, don't add numbers or letters. Anything that won't fit on the form, put it on a separate sheet of paper, clearly identified, and attach it. Do not alter the form. These forms are formatted in a very specific way that make them acceptable for submission to the state's e-filing system, and they just cannot be altered. So they want to know who you were previously married to, how the marriage ended, where the divorce was granted if you had a divorce, and they ask it for every single previous marriage that you have had. Then you repeat for joint petitioner B, and if you need additional sheets, of course, go ahead and use them. But just who you were married to, how it ended, where it ended, that kind of information. Very straightforward. Now, this is a joint petition for divorce without minor children, but that doesn't mean that there aren't any children of the marriage. They would just be age 18 or older. So you have the option to say, no, there's just no children born or adopted. Or you can list any children who are age 18 or older and born to a party, adopted together by me and the other party during the marriage, include names, dates of birth. So finally, if you have come to an agreement with your spouse, and hopefully you have because the two of you are planning on filing a joint petition, the court would like to know if the two of you have already worked anything out. If you want to work together to figure out what you want for things like property division or spousal support, you can write that up and attach it as a copy to the petition. The court really appreciates it when parties can resolve things amicably on their own with minimal court involvement, and it doesn't turn into a contentious battle where the two of you are fighting over the lawn furniture from the cottage up north. But it does happen, and that's okay too. You would just hit no. This is interesting. You should know of this. You consent to the jurisdiction of the court and you waive service of summons. That means we're filing this together. We both already know about it. We agree we're going to do it in this court. We don't need to have service because we're doing this together. So that's what this little sentence means here. You're not waiving any further rights. You're just saying, we're preparing this together. We know where we are. This is where we want to be. Everyone's fully informed. Let's move forward. So here is where you make your request of the court. What are you asking the court for? You're asking that the court grant a judgment as requested. And this is a sticky point. If you want any spousal support, you need to ask for it here. And if you've perhaps come to even a rough written agreement on spousal support, you would attach. But you need to ask in the beginning. It's tougher to come back later and ask for spousal support if you just didn't even bother in your initial petition. And then third, finally, enter other orders as the court deems just and equitable. So before you sign this joint petition, the court has a warning for you. Neither party can participate in any of the following activities while this action is pending. So 1, harassing, intimidating, physically abusing, or imposing any restraint on the personal liberty of the other party or a minor child of either of the parties. So a lot of the time, things start out fairly friendly, and the two people just decide to jointly petition, but it doesn't always last. Things can devolve quickly if you're fighting over assets or how they should be divided, or if you're fighting over debts. So this is just forewarned is forearmed. You can't engage in any of these behaviors during the pendency of this action. Second is more financial. You can't encumber, conceal, damage, destroy, transfer, or in any other way dispose of property owned by either or both of the parties. You're still married. You might have access to your spouse's checking account or be an authorized signatory. You might sell something that you purchased during the marriage and then give the proceeds to your parents to hold on to for you until you end up getting divorced. That kind of thing. You can't conceal or transfer or do anything with any marital property because it's involved in the divorce and it needs to be divided up going through the court. However, you can, of course, run your business normally, in order to secure necessities or in order to pay the reasonable costs and expenses of the action, including attorney's fees. So you can still pay your bills, of course, but you can't go out and take out like a home equity line of credit on the marital home and just forge your spouse's signature or get away with it because you're still legally married. You just can't make any big financial moves or try to hide anything because they'll find out. And here's what happens when they find out. A violation of the above prohibitions may result in punishment for contempt, which may include monetary penalties, imprisonment, and other sanctions as provided for in Section 785.04. So just don't get nasty, and don't try to be slick and hide anything or sell anything off. It's not going to work out. And these all apply until the action is dismissed, a final judgment of action is ordered, or the court orders otherwise. Sometimes the court will order that something could be sold off, but that would be with everybody knowing about it and understanding it needed to be done. So then we just have the two signature blocks left. This is not a petition that has to be notarized. You can just sign it. You don't have to go sign it in front of a notary. Just remember who A and who B are and stick with it throughout the form. They do have a little spot here at the bottom for a bar number, but that would only be if you're represented by an attorney. And finally, and again, don't modify the form. You can just add extra pages, but don't change the original form because it's got a very specific formatting. So that is how you would fill out the joint petition for divorce or legal separation without minor children, or Form FA 4111V. To learn more about divorce in Wisconsin, you can visit our page, which is linked below. And be sure to leave any questions you have in the comments section. And you can always subscribe to us for more legal content daily. But thank you so much for watching.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.